During a medical malpractice trial here in New York, is it ever appropriate for a defense attorney not to make opening arguments after the plaintiff's attorney makes opening arguments? You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you should know that the plaintiff is the injured patient, the one bringing the lawsuit. The defendant is the one who is being sued, the doctor or the hospital staff that are being sued. So you know from watching TV and courtroom dramas and seeing movies about cases and trials, you know, or at least they portray, that the injured patient now brings a lawsuit and now the attorney, the plaintiff's attorney, makes opening arguments. And in logical sequence, you would expect the defense lawyer to then get up and to make his opening arguments, which basically says, hey, we did nothing that they're claiming. We did nothing wrong. And even if we did something wrong, so did you. And if we did something wrong and so did you, guess what? Whatever we did didn't cause or contribute to your injuries. And by the way, even if we did something wrong and you did something wrong, and maybe I did something that caused your injuries really are not as bad as you claim them to be. Those are the typical defenses that we find in all of these civil lawsuits involving medical malpractice and wrongful death and even accident cases. So now at the very beginning of the trial, the judge will make opening remarks to the jury to give them preliminary instructions on what to expect during the course of the trial. The injured patient's attorney gets up and then makes his opening arguments. And now the judge turns to the defense lawyer and says, "Counselor, you may make opening arguments." Is there ever an opportunity for the defense attorney to say, "Judge, at this time I choose not to make an opening argument"? The answer is yes, that is possible. Now why is that? I'll tell you why. It's because the injured patient and her attorney have an obligation to show that they are more likely right than wrong, that what they are claiming is true. They have an obligation to put on whatever proof they feel is necessary in order to show that they are more likely right than wrong, that number one, the doctor was careless, number two, to show that his carelessness was a cause of the injury, and number three, that the injury is significant and or permanent. That's their obligation. So now the plaintiff, the injured patient, puts on all of their testimony, all of their experts, all of their witnesses that they need in order to prove their case. But the reality is that an injured patient doesn't really have to prove anything. All we have to do is show that we are slightly more likely right than wrong. And if we are able to do that, then we are entitled to a verdict in our favor. Now, on the other hand, the defense may choose for a strategic reason or a tactical reason. They may choose, you know what? Let's see the plaintiff, the injured patient, put on whatever evidence they need. We will obviously have an opportunity to go ahead and cross-examine those witnesses who get up to testify. But after the patient has put on all of their testimony, the defense lawyer is going to stand up and tell the judge, "Your Honor, at this time, we want the patient's case dismissed." Why? Because they have not put in sufficient evidence to justify a verdict in their favor. So what the defense will try and do is they will try and short-circuit the entire trial. They will try and prevent the need from ever having to put on any evidence or any witnesses. Why? Because they anticipate, or they're hoping, that the judge will recognize that the injured patient's proof is insufficient to allow them to go to the jury for the jury to make a decision. That's very powerful. Now, does that happen often? The answer is no, it does not happen often. Sometimes a defense attorney will strategically do this and say, you know what? If I have to make opening arguments, I want to do it after the injured patient and her attorney have put on all of their testimony. Then I would like the opportunity to make my opening arguments and then begin to put on my witnesses. And the judge should allow him to do that. But you will find that most attorneys, most good experienced trial attorneys, have that urge, have that desire to immediately stand up and rebut the arguments that we are making. So we go first. We are the ones who present our information, our evidence, our testimony first. And we're the ones who make opening arguments first. And now there's such a great temptation by the defense attorney to get up there to show the jury that everything we said was totally incorrect. And they believe oftentimes that the best time to make that argument is immediately after we make our argument. Why? Because it's fresh in the minds of the jury. Otherwise, the jury gets a one-sided view. Their perspective is only of our argument, of our claims. And the only time the jury will see that there's really any opposition to our claims that are being made is when the defense lawyer gets up to cross-examine particular witnesses. So many defense attorneys will say, you know what? I don't want to leave the jury with that perception that we agree with the injured patient's claims. And you will find that the best defense lawyers in New York tend to make their opening arguments immediately after we make ours. So why do I share this great information with you? I share it with you because this does happen occasionally. And now, if you're sitting in the back of the courtroom, or if you're a litigant, and now see this happen, you may be wondering, wait a second, why would the defense not make an opening argument right away? Why would they choose to wait? Why would they choose not to cross-examine their own doctor now and choose to do it after the injured patient has put on all their testimony and evidence? Well, now you know the reason. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.